Why didn't y'all tell me that Jeanette Braun lost on her copyright claims against the Do We Know Them podcast host, Jessica Vasquez? Did I say that wrong? Probably. And Lily Martin twice. She didn't lose one time. She lost twice. And if you don't know who Jeanette Braun is, she is actually an IP lawyer, an intellectual property lawyer. So when she's filing copyright claims with the Copyright Claims Board, I would think that she should know what she's doing. I'm not quite sure if she was actually represented by a separate lawyer on this. I did not look into that, but maybe I'll check that a little bit later on. But anyways, she lost twice. So what we're going to do today is we're going to look at the initial denial of the copyright claim that Jeanette Braun was trying to make, which was very thorough, I might add. But then Jeanette Braun asked for the Copyright Board to reconsider it, and as a lawyer, didn't cite to any new law or new fact in asking them to reconsider. We're not going to go over her reconsideration because we don't want to be here all night, but we are going to go over the Copyright Board's second read on Jeanette Braun because she was not acting very smart. One interesting thing that I did find in the initial final decision is that they made reference to the fact that Jeanette's arguments, or Jeanette's, what's her name? Jeanette, her arguments were not credible coming from a lawyer. For you to get called out by the Copyright Board, who probably has law degrees, I'm sure, lawyers, probably judges, probably, I don't know who works there, but for them to call you out as not being credible at the same time that you have defamation lawsuits going forward against you for, what did they say? That maybe she perjured herself. They said that she was rogue, all of these things, right? And potential bar complaints against her, all of these things. But for the actual Copyright Board to say that your arguments are not credible, I can only wonder if we're going to see a defamation lawsuit going against the Copyright Board at this point. So y'all know we are live here in the BriHive. If you're watching live, make sure you are dropping in the chat your thoughts on this as we go through everything. And if you're watching on the replay, make sure you are dropping down comments below and your thoughts on this nonsense that Jeanette has going on. And if you're on the replay crew, there will be timestamps down below so that you can kind of skip around to whatever point of the stream that you want to look into. But for those of you that are live, you just have to kind of suffer through this with me, okay? You have to suffer through Jeanette getting read by the Copyright Claims Board with me today. And we've already suffered through her being read by the judge in the actual defamation lawsuit that she had filed. But now we are going to be going through this Copyright Board's. I don't understand. I don't understand. And I did not know that she was asking for copyright claims for one of her own videos. I actually thought this was for her clients, but let's get into it. Let's have Bossy B bring us right into this mess. The drama, the mess, it's gonna go on. All right, y'all. So if you don't know the story, we are talking about Jeanette Braun. She is an attorney that was on TikTok, and she had a couple of clients on TikTok, big stars, who I would consider big TikTokers, like Lauren the Mortician and some other people that she was representing. And she started to get a reputation of basically filing false copyright strikes, basically claiming any and everything as copyright strikes, while the creators were calling these actually fair use. And now one thing to understand about fair use is that it doesn't mean that you are not infringing on someone's copyright just because it's fair use. It is actually a defense to copyright infringement. When we're talking about copyright infringement, we're talking about somebody copying your works. And your work can be a video, it can be a book, it can be art, it can be anything that you put into a tangible medium that is copyright protected. And like me being on this video right now, I automatically have copyright protection, common law copyright protection for this YouTube video. If someone uses it and tries to pass themselves off as me, don't know why they would want to do that, but they might do it pass themselves off as me, I can say, hey, you infringed on my copyright. And they may say, yeah, boss attorney Bree, I infringed on your copyright, but it's fair use because I'm talking mess about your Winnie the Pooh shirt. I don't know where I come up with these things, y'all. Things just come off the top of my head. Anyways, so although they used her video, allegedly, well, I guess it's not allegedly, they basically didn't contest that fact. They had the argument that, well, it was fair use because we were giving commentary on it. And the copyright board, unfortunately, agrees. And I'm saying unfortunately for Jeanette, but fortunately for the Do We Know Them podcast, they agree with them and say, no, this is fair use. They're clearly talking smack about you. Like, I don't get what you don't get, but they're talking mess about you, Jeanette Braun. I don't know what you want us to do here. So let's go ahead and jump right into it. And this is her copyright claim. We have already gone over the defamation case. So if you missed that video, I should probably link it in the description box if you want to also see the actual federal courts reading her. Today, we are just talking about the copyright board reading her. So let's go ahead. And I had a different setup that I wanted to use. This one is this one. Oh, no, my face is covered. Ah, gosh, Brianna. Let's see. Let's do this one. Okay, we'll be up here in the corner. So we have the final decision from the Copyright Claims Board. This is a lawsuit, or I guess a copyright claim by Braun IP Law LLC. So she's actually suing as her law firm, or not suing, making the claim as her law firm against Jessica Vasquez and is it Vasquez? It's probably Vasquez, huh? And Lily Martin. And this is the final determination, y'all. This was going on for almost a year and a half before this decision came out. So this matter has been fully submitted by the parties, and actually not a year and a half. It was a year and a couple of 2 months. Okay. Anyways, this matter has been fully submitted by the parties for the reasons that follow. The Copyright Claims Board finds in favor of respondents Jessica Vasquez, and I feel like I'm still saying it wrong, and Lily Martin. Collectively, they're going to call them the respondents, and dismisses the claim against the respondent with prejudice. So Jeanette Braun loses again. And I wonder if this is going to make her not want to go forward with the actual defamation case, because she did win on some stuff against Lily. Okay. And she could potentially bring back claims against Rebecca Day from that defamation lawsuit. But for everyone else, for Caffeinated Kitty, it was dismissed with prejudice. For Jessica Vasquez, it was dismissed permanently. But for some of the claims against Lily Martin and against Lily Martin, they were not dismissed. And then one of them could be brought back if Jeanette basically pleads the proper thing she was supposed to plead. So anyways, this is for the copyright, not the defamation case. Procedural history. This claim was filed on December 11, 2023 by Braun IP Law LLC. The board found the claim compliant, and on December 12, 2023, directed Braun IP to serve respondents. After service on respondents, the board did not receive an opt-out form from either of them. On February 21st, 2024, the board notified the parties that the claim had entered the active phase because the respondents did not opt out, ordered Braun IP to pay the second filing fee, and ordered the respondents to register for the board's online docketing system. Vasquez, I don't know why I can't say it. I hope I'm saying it right. Vasquez filed her response on May 13th, and then Lily filed her response on May 14th of 2024. On August 29, 2024, the board issued an order closing discovery as of September 6, 2024, and ordering the filing of written testimony. For its written testimony, Braun IP filed evidence and an evidence list, as well as a party statement, but not any separate witness statement. Respondents filed evidence and an evidence list, as well as a party statement, but not any separate witness statement. Braun IP filed a reply party statement on January 2nd, 2025. This case is now ready for final determination. So they submitted their evidence and they submitted their statements about what's going on. There is a footnote that each of them submitted these statements, but they were more like legal arguments. So basically they submitted the document improperly, but the court is just going to go ahead and take that. And so the procedural history just let us know everything that has already been done in this case and how we ended up where we are. And how we ended up where we are is going to be handled in the factual history. So let's see what Jeanette Braun is actually upset about, because the procedural history didn't really help us with really determining what the heck this lady is mad about. So let's look at the facts in this case. The facts relevant to this final determination are largely uncontested. Braun IP states that respondents do not dispute, or Braun IP states and respondents do not dispute that Braun IP is the copyright owner of a video of an approximately 8-minute and 40-second long video titled Becca Day False Accusations. The work was first published by Braun IP on November 29, 2023, and was registered with the U.S. Copyright Office as a motion picture, with an effective date of registration of December 5th, 2023. And the reason why she needed to register the copyright is because it allows her to get more damages when she is suing someone. So if there's a registered trade, or if there's a registered copyright, you are basically put on notice, constructively put on notice that this person has the copyright, so you're not supposed to be infringing on the work. And they can basically get like punitive damages against you to punish you because you violated a federal copyright. If you just had the video and you didn't actually file the federal copyright, you would still be able to win money. It just wouldn't be as much as if you don't have the federal copyright filed. So she went ahead and filed her federal copyright, and then she also filed this motion or this claim with the Copyright Board. Claimant's papers say little about the creative aspect of the works because it's just Jeanette talking on the camera. I don't know what creative thing she could say she was doing. Where were we at? Claimant's papers say little about the creative aspect of the works beyond saying it was a scripted and produced video that comprises of set designs and other artistic elements. It was her sitting and talking on a video. So I don't know why she's saying it's artistic, but that's what she put, okay? The work itself, however, makes it relatively clear what it is. A review of the work establishes that Braun IP, or Jeanette Braun of Braun IP, the papers state that Braun created the video on behalf of Braun IP, was involved in an online dispute with a woman named Becca Day. Braun is an attorney who has filed takedown notices on behalf of clients to get material removed from online service providers such as YouTube. It is unclear how far back the dispute between Day and Braun goes, and from respondents' video in question, it appears without being clear that others may have also been involved in the accusations against Braun. But at some point, Braun felt the need to defend herself and posted her defense, the work, to TikTok. So as you can kind of tell by how this is being written, it kind of seems like the Copyright Board is already annoyed with Jeanette Braun. Like, they're having some beef online, and Jeanette decided she was going to respond via video on TikTok as a grown woman. So you can already tell that the Copyright Board is not really entertained by this, okay? The entirety of the work depicts Braun sitting at her desk in an office, and it appears to be recorded on a computer or a camera phone or a phone camera. Not every detail is they didn't have to call her out for the fact that it was either recorded on a computer or a phone, because remember, she registered it as a copyright for a motion picture. Okay. And usually when we are going to the movies to watch motion pictures, we are not watching things that were recorded on your camera phone or on your computer. So they're already being a little shady here, in my opinion. Not every detail is necessary to this determination, but generally Braun goes through a factual recitation of how Day, who Braun says describes herself as an investigative reporter, is spreading allegedly false information about Braun and Braun IP. Day's main accusation is that Braun is filing false copyright strikes against small creators such as podcasters and influencers on the internet so that she can get things her clients do not like taken down. Braun states in the works that a purpose of creating the work is to talk through how it is impossible for her to do that. Although her main argument is highly semantic. So we are 3 pages in, and the Copyright Board is calling basically her explanation semantic. So it doesn't sound like they're agreeing with her. She's just spewing nonsense is basically what they're saying. that she does not file copyright strike, but rather files a request to strike and the online service provider performs the strike. Braun states in the video that because Day has chosen to bring the dispute into social media court, Braun is going to otherwise respond over social media. In fact, she specifically says that the viewers of the work are likely here for the tea and here for the drama. She also says that the work was created to address the false copyright strike accusation and will not address some of the other drama in their dispute, saying that she is reserving her testimony to be made under oath. Yeah. They go ahead and go on to say that respondents' business revolves around and use the words from the work tea and drama. They run a video podcast on at least YouTube called Do We Know Them? And they're going to refer to that as the podcast. A standard episode of the podcast is the two hosts, Vasquez and Martin, sitting in chairs. They are not in the same room, but the video is shot to make it look more like they are, talking to each other about drama they find on the internet. The podcast has over 100,000 subscribers, primarily young adults, according to respondents, who clearly enjoy watching Vasquez and Martin give their opinions on the petty fights of others. As such, the Day Braun fight was fresh meat for the podcast. Because of Braun's involvement with the drama on the internet, the podcast had already discussed Braun prior to the work being published. Braun had represented another internet celebrity respondent called Lauren the Mortician, which also involved a dispute related to copyright takedown notices. In an episode prior to the one alleged as infringing, the podcast had gone into detail about how Lauren had allegedly hired Braun to take down content of anyone Lauren did not like. And according to the podcast, Braun had taken certain other aggressive actions on Lauren's behalf, even threatening jail time in a cease and desist letter. As we know, that's going to involve like Caffeinated Kitty. Like everyone's being dragged into this, but this is literally only between Jeanette Braun and Jessica and Lily. So why everyone else is being brought into the nonsense? I guess because it's a reaction to a video that Jeanette Braun did about what she thinks that Becca Day was saying was false. Now, she can get on the internet and give her opinion, but apparently, based on these motions and these lawsuits, in my opinion, is that no one else can give commentary on her. It's bad if you're commenting on her, but the court does not. They do not go easy on her, okay? So respondents had therefore been monitoring drama related to Braun when they filmed the allegedly infringing episode. Posted on YouTube on December 2nd, 2023. In the episode, respondents' main story is dedicated to Braun. The title of the 1 hour, 24-minute episode is Lauren the Mortician's Lawyer is Way Worse Than We Thought, plus Vlog Squad, Where Are They Now? After an approximately 5-minute introduction discussing various things in their lives, they started discussing Braun by referencing their prior episode. They explained that they had gotten many comments and messages about Braun and that they had now realized she was infamous, perhaps you could say, in the creator community for going after fellow drama commentators. Now, they're going to go into the full episode of what Lily does. Remember, we are having this live stream because Jeanette Braun, after this final determination, decided that she was going to file a reconsideration. As we can tell, the Copyright Board is doing a really, really good job in making sure they're including all the facts that they are considering. As we go through this, I want y'all to pay attention and recognize that they are citing timestamps. I'm not going to be citing the timestamps, but y'all be able to see it on the screen that they cite timestamps. They cite the specific facts that they think are important. They are very detailed talking about this video and the facts that they think are important to their determination. So when Jeanette Braun is asking for a reconsideration, it's completely ridiculous. And we'll get into that a little bit more when we get into the decision on the reconsideration, because they are listing all the facts. And in order to have a valid reconsideration, you need to say that the court missed or the board missed some facts or there's some new law, right? But that's not what's happening here. So make sure y'all are paying good attention to all the details that the board is going to go through of what they're considering important in determining whether Jeanette Braun has a claim here, right? So respondents spent a lengthy amount of time discussing others in the drama community, including images and clips from videos to show the history of Braun and her actions on behalf of clients. In the episode, respondents make clear their distaste for Braun and what they view as Braun's lack of standards, going so far as to make the decision to call her Janet instead of her real name, Jeanette. And remember, she was really salty about that. Doesn't seem like the board really is taking any kind of interest of whether that was mean or not. I mean, because that's not what they're there to decide. At the 22-minute and 30-second mark of the episode, Martin decided to check Braun's TikTok account to see if she had posted anything more about her disputes. And upon seeing that there was a posting about Becca Day, that is the work that we're talking about today, respondents proceed to give their live reaction to the posting, whether this was an actual immediate reaction to the work, which is not live but is taped in advance, or whether that was said to increase drama, is not material to the determination. Initially, the episode plays just 20 seconds of the work. The part of the work in which Braun states that Day is making false accusations and that it is impossible for Braun to have filed false copyright strikes. The episode pauses the work before Braun further explains her reasoning in the work. This was because respondents were confused by Braun's statement, given that, according to the respondents in the episode, they recalled Braun herself previously discussing people filing false copyright strikes. And as discussed in the prior episode, the core of Day's issue with Braun was her threats and other aggressive tactics to content creators. And Day had read Braun's cease and desist letter to a third party on Day's video. Respondents note their belief that Day and Braun are going back and forth with each other because Braun is pissed that Day is calling out her tactics. The episode then shows a video from Day in a faster speed than typical, where Day goes through some of the history of her dispute with Braun, although the Day video is stopped when respondents are struck with the realization that Day has made a reference to someone who had emailed respondents after their prior episode about the person's dispute with Braun and claims that Braun was filing false takedown notices against her with respect to various material. Respondents then discuss the drama as well. So it's already being brought up. Jeanette is having all these problems with these people in the community. I'm sure it's appearing to the copyright board that she is a problem, that Jeanette is kind of harassing people. And that's what it seems like the board is starting to feel like. Why are all these people coming to these commentators telling them about everything that Jeanette Braun is doing to people, right? So let's jump back into it. Where were we at? Respondents continue with a lengthy exposition of the drama and history of various internet celebrities and Braun's actions on their behalf, including one celebrity who was so pleased with Braun's tactic that she recommended Braun to others. Sounds like this person might start to regret it, right? She recommended to others, which eventually caused a fight between many people with Braun at the center. The history uses different clips, including one from Braun's clients saying that she has Braun take down material, including when anyone tries to defame the client or talks mess about the client, and that the client loves when they get upset about it. During the exposition, respondents make clear they're discussed with Braun and creators who they believe harass and bully those who say things they do not like. As part of the episode, respondents discuss the concept of fair use at some length, as they believe the tactics Braun is defending in the work involve going after creators engaging in fair use, and respondents' business and many other on the internet rely on the legal principle to discuss and critique various personalities and influencers and report on drama between them. So they're basically kind of covering their butts. We're about to talk about Jeanette Braun. We're about to play some of her video. But Jeanette, while you're watching this video, well, this is fair use. So they're coming straight out and saying, yes, I understand that I don't have permission to use your video. However, we are going to critique you and it's fair use. So in other words, don't try anything crazy. And what does Jeanette try? Yeah, what did she go ahead and try? Sounds like something crazy. So, respondents state in the episode that podcasts like theirs engage in commentary and use videos in a transformative manner to give accurate context to their critiques so that audience understands why they are agreeing or disagreeing with the content. They also call out Braun and her clients as being hypocrites for sending takedown notices on content very similar in nature to the content that those clients are also creating. That is, content using the works of others to give context to critique and analysis. Context to critiques and analysis. Within the fair use discussion, respondents show they show at some time frame of a different video that Braun created, not at issue in this proceeding, and supposedly a year earlier, where Braun herself actually tells her viewers that anyone wanting to submit a takedown notice must consider fair use first. So she advises her clients to do that, but allegedly, based on this copyright filing, she does not do so herself. And we're going to get into how Jeanette was already put on notice that fair use applies in this context, if she didn't already know as this experienced IP lawyer. I think she should have already known that as an experienced IP lawyer, but whatever, this is the way that she wants to do things in order to get her point across. So respondents call out Braun for being hypocritical and perhaps changing her tune when she can make money from takedown notices. Respondents discuss how Braun's statement in the work that she herself does not perform a copyright strike, but merely presents a request for a copyright strike, and the strike is performed by the platform is mere semantics. It is at this point that the episode plays a precisely 1 minute long clip. Some of it was that 20 seconds that were played earlier in the episode to show and criticize how, as explained above and as referred to at various points in the episode, Braun used what respondents consider to be very technical and disingenuous semantics to defend her actions with Day. No other portion of the work was shown in the episode. Remember, the video that they are talking about, that they are watching, that is Braun's, was 8 minutes and 40 seconds. They only played 1 minute of her video, which is interesting, right? 1 minute of her video, and their actual live stream was 1 hour and 20 some odd minutes. So very short, 1 minute out of, what is that, 80 something minutes? I don't think that's a lot, but y'all let me know what y'all think about it. The episode continues discussing more of Braun's activities against internet commentators and influencers, including doing enough to get pages banned and including, according to respondents, trying to take down material that could not possibly be protectable under copyright law. Respondents also state that they fully expect Braun to file a takedown notice against them and that they would have no problem issuing a counter notice given their confidence that their uses of the work constitute fair use. At the almost 70-minute mark of the episode, after further discussions of Braun's clients and her activity on their behalf, respondents again discussed the importance of fair use principles and the difference between using a takedown for alleged defamation and copyright infringement, and then in their discussion related to Braun and Braun's clients. There is no dispute regarding respondents' lack of permission to use the work in the episode on December 3rd, 2023. Braun IP sent a takedown to YouTube regarding the episode, and the respondent sent YouTube a counter notice. Respondent, although YouTube opinion does not factor into the board's decision, YouTube sent Braun IP an email on December 8th and the respondents an email on December 12th, 2023, stating that they had unilaterally made the decision that regardless of when Braun IP filed a copyright infringement lawsuit concerning the episode, they would not take the episode down because YouTube independently determined that the episode's use of the work clearly fell within the category of fair use. So, like I said, even if Jeanette Braun, as an experienced intellectual property attorney who does copyright strikes, even if she did not know that them playing 1 minute of her video in 1 hour and 20 some odd minute podcast and then commenting on her position not being the brightest, even if she did not know that was fair use, As of December 8th, 2023, she had noticed that at least one entity who is built on whether people are infringing, right? Where YouTube people are making videos, they are the owner of their content. You can't steal other people's content. They themselves have found that this falls within fair use. So even if you, as an experienced attorney, did not know, Jeanette Braun, that this was fair use, YouTube told you it was fair use, and they're not going to take the video down. So what in your mind makes you say, okay, well, YouTube thinks it's fair use, but I'm going to take it a step further, and I'm going to go directly to the Copyright Claims Board, and they're going to agree with me. I'm going to take this through a year-long process, and I think they're going to agree with me. The first notice to YouTube shouldn't have been filed. And then definitely this Copyright Claim Board thing shouldn't have been filed. We understand that you own the video, but we're talking mess about you, which we're allowed to do. Commentary. It's specifically in the statute that you can use it for commentary, right? Regarding respondents' potential profits attributable to the alleged infringement, Braun IP states that respondents made $4,226.61 in revenue from the episode on YouTube and $1,236.24 from audio-only versions of the episode on other platforms. Regarding possible losses of Braun IP, get this, y'all. Braun IP states that it uses a standard licensing agreement for videos it creates, for which it charges $7,500 and attaches 2 sample licensing agreements, although it is extremely unclear what types of video the licenses cover and whether those videos are anything like the work. Oh my gosh, Kimmy, can you create a poll asking the chat whether they think that anyone has paid $7,500 to license one of Jeanette's TikTok videos? Who's paying $7,500 to license Jeanette Braun's TikTok videos, yet alone Jeanette Braun's TikTok video talking mess about Becca Day? Who's paying $7,500 to do that? I don't know how you want to word the poll, but if you can make a poll, I would like to know what the chat thinks. If anybody would license Jeanette Braun's video. It's not even one of her educational videos, right? It's one of her videos defending herself and online drama. And you want someone to pay $7,500 for it. It to me sounds made up. But hey, to each their own. She gotta make claims for damages. Okay. So she attaches the agreements of, I guess, other videos that she's licensed out. Respondent states that the number for the revenue is overstated. There is no evidence that anyone has paid Braun IP's claimed license rate. One of the 2 sample agreements allows services in lieu of payment, and the work is extremely different from any of Braun IP's past content. Respondent, that was it. Braun IP seeks statutory damages of no less than $12,962.84. So she wants almost $13,000 from them for this alleged copyright infringement that she thinks happened. What do y'all think? Those are the facts, which brings us here, which why we're even having a copyright claim. Those are the facts in front of us. Jessica and Lily of the Do We Know Them podcast made a video commenting on 1 minute length of Jeanette Braun's video. Okay. Talking about Becca Day is not telling the truth about Jeanette Braun allegedly issuing false copyright strikes, basically doing, sketchy things to get her creators ahead. And Jeanette Braun actually describing how fair use works in other videos. She didn't try to copyright strike them for that video, mind you, that she knows what fair use is. She didn't try to copyright strike them for that. What they're trying to copyright them for is the video basically saying that Rebecca Day is wrong. despite already having this other lawsuit going forward, right? So they should have paid her $7,500 to even talk about her. Yeah, freaking right, Jeanette. Janet. Yeah, right. No one's paying you $7,500 to talk mess about you, to use the video to be able to talk mess about you. Come on, you know what fair use is. And I would like to know why she didn't copyright strike them for that video. Because it would have shown she knows how fair use works. That's what it would have shown. Okay, let's go ahead and jump into the defenses, because like I said, no one is contradicting that it is Jeanette's video. She made it on her camera phone or computer, according to the copyright board. Not probably the best motion picture is what I'm getting. No one's contesting that that's her video. They don't care. That's her video. What they are saying is, yes, while we may have copied her work by playing it on our podcast, briefly, mind you, we have the defense of fair use. We only used it because we were making commentary on it. Okay, so let's get into their explanation of the defense, or the board's explanation of the defense. So to succeed on a claim for copyright infringement, a claimant must establish ownership of a valid copyright and opposing of constituent elements of the work that are, and copying of constituent elements of the work that are originals. Respondents do not contest Braun IP's ownership of the work, which is documented in the certificate of registration and which acts as a prima facie presumption of copyrightability and ownership of the work, nor do they contest that they copied constituent elements of the work, which is clearly evidenced by a comparison of the works at issue. However, respondents claim that their use of the works qualify for the fair use defense. As the proponent of an affirmative defense of fair use, respondents have the burden of proof on this issue. Four non-exclusive factors are considered when analyzing a fair use defense. So these are the four things that Jessica and Lily are going to have to prevail on. So 1, the purpose and character of the use, including whether such use is of commercial nature or is for nonprofit educational purposes. The nature of the copyrighted work, the amount and substantiality of the portion of the portion used in relation to the copyrighted work as a whole, and the last one, the effect of the use upon the potential market for or value of the copyrighted work. Based on the evidence in the record, the weight of the factors overwhelmingly favors a finding for fair use. And the court explains why. So let's talk about the first factors. As for the first factor, while the use of the work was for a commercial podcast, there is no question that the use was to comment on and criticize content of the work. Respondents used the 1-minute clip to accurately report on the story they were discussing and to allow their viewers to understand the context of the story and their critiques of Braun and the precise content in the clip. Braun IP suggests that the clip was used for its original purpose, which was to provide Jeanette Braun's and Braun IP's side of an online dispute between her and another online content creator. Yes, they wanted people to see how ridiculous your claims were. But that was not the purpose. They didn't comment on it. Like, is she like purposely being dense? Like, is that what she's trying to do? She was like, no, they used it because they wanted to bolster my side of the story. Newsflash, Janet, nobody wants to bolster your side of the story. It's clear that they're talking mess about you. Okay? Anyways, let's go on. However, respondents' use was literally for the opposite purpose. The board is not happy. Literally for the opposite purpose, girl. Get it together. Namely, to give reasons why Braun's side of the story did not hold water. Not the court or the board saying your side don't hold water, okay? To do that, respondents needed to present Braun's reasoning, and they used no more of her content that was reasonable to critique it. They only played a minute of this, and it was an 8-minute and 40-second video. There is no doubt that this falls into the category of criticism and commentary explicitly set set forth in the statute. To be clear, while respondents could be accused of insulting or belittling Braun, the episode is far more than that. It is a lengthy and comprehensive history, review, criticism, and dismantling of the arguments presented by Braun in the 1-minute clip of the work shown in the episode. So the court or the board is eating her up. We're eating her up, okay? They did not play your clip to bolster your side of the story. And even if they did play your clip to bolster your side of the story, you should be happy. You should be happy that they're spreading your word because no one else was on your side. You should be happy that they were helping you out and getting the word out and why you think you are right, even if they were doing that. But instead, the reason why we want the video taken down, because yes, they do play your side of the argument and get your side out there, but they also talk mess about you for a very long time, okay? And so that makes you look bad. You don't need to take down an hour and 20-something minute video because they played 1-minute clip from your video. They're not bolstering your position, but even if they were, like I said, she should be happy. She should be happy about that. Anyways, let's go on. Many courts have found that copying of a work in the context of commentary or criticism on the subject within the work or use of the work to enhance a movie or video discussing the subject of the work qualifies for the fair use defense, and at the very least, it strongly tilts the first factor analysis towards the defendant. In fact, in similar situations, courts have specifically said that when one video is used to present a point of view and the second video uses the first to criticize that position, the use is fundamentally at odds with the original purpose of the first work and therefore inherently transformative. So, on to the side of the podcast. And so I'm just skipping through all of this because this is just citing cases where similar findings have been made. On to the second factor. There is some question as to whether, let me actually make some comments about that. So court says it's transformative. They're talking mess about you, Jeanette Braun. They are not bolstering your side. They are not trying to help you, okay? And even if they were trying to help you, or use your opinions and your thoughts, you should be happy that they're spreading your word. Okay? So, first point for the Do We Know Them podcast. So, they're winning. They're in the lead. 1 point for them. As to the second factor, there is some question as to whether the work is creative in nature. The work was not made for entertainment purposes, but rather for Braun to go through the factual history of her dispute with Day and her position related to this dispute. So they're talking about Jeanette Braun's 8-minute video of her saying, Rebecca Day is being mean to me, okay? And she's lying about me, and that's not okay. So it's not made for entertainment purposes is what the court is saying. Courts have found that when the original work is informational in nature, more leeway is given towards finding fair use. Let me see, where do we need to go here? As such, this factor is neutral in the analysis here, or at best, slightly weighs against fair use. Did I skip some stuff? Give me a second, y'all. Oh, I did skip some stuff. So if it's informational, it weighs closer to fair use. And then they go on to say, however, even assuming that the board viewed this as a creative work, the weight of this factor is almost negligible when the use of the creative work is for a clear transformative purpose, such as criticism and commentary. Okay, I'm just trying to find the next thing. Sorry, y'all. There was like some weird noise in here. So basically, if it's the second work is commentary, so it's going to weigh more in favor of them. And then I don't see their other reasoning. But anyways, they said, that was the reasoning. So they said they was informational, and then the commentary. Did I read that right? Okay, so they gave her the benefit of the doubt of if it was considered a creative work, she still is going to lose on that point. So, but they're basically just calling it neutral to avoid the argument of whether it's creative or informational. with her talking about the drama in the case. Okay, sorry about that, y'all. And then we're going to go ahead and jump into the third factor. The amount and substantiality factor weighs somewhat in favor of fair use. In terms of the clip's relation to the work as a whole, respondents took only 1 minute out of the 8.5-minute video, which amounts to approximately 11 to 12% of the work, while claimant objects that what was taken was the heart of the work. There is no evidence to support that position. Braun IP also says that the fact of the matter is that respondents did not need to display any portion of the work at all. That argument is meritless and undermines the claimant's credibility. So for you to say, as an intellectual property attorney, that there was no need for them to play any part of the video in order to critique it, the board finds that meritless, and it goes against your credibility. So, final decision, they are concerned with Jeanette Braun's credibility. You know who else was concerned with Jeanette Braun's credibility? Everybody in the lawsuit that she filed for the defamation. Everyone was concerned with her credibility. And now we have the copyright board, an official government entity, being concerned with Jeanette Braun's credibility. Now, could this mean that they report her to her bar? Potentially, they can. They have concerns with her credibility. Is she committing malpractice by filing this copyright claim, knowing that it falls within fair use? Or at least, according to them, most of the factors fall in favor of fair use. So the board is already questioning her credibility, and we're not even done with the decision here. So, as discussed above, respondents clearly used the work to provide context so that they could properly critique it. Furthermore, it does not appear that respondents used any more than was reasonable to use, limiting their use of the work to the specific parts they were criticizing. Furthermore, this is not a case where respondents used a work and made minimal commentary. They spent over an hour criticizing a 1-minute clip and the events surrounding it. It's like they talked mess about you for several minutes, ma'am. For several minutes, they talked mess about you. They played 1 minute of your video and talked about you for an hour, sis. I think it's fair use, okay? Finally, on to the fourth factor. There is no meaningful evidence that the use of the work affected the market or value of the work. Respondents took a small portion of the work to criticize its content. To suggest that respondents use sorry, y'all. What I got going on? Where am I at? And where was I at? I lost my spot. Okay, there we are. To suggest that respondents' use interfered with Braun IP's law's ability to monetize the works on online platforms, claimant states that both parties operate within the same online content market. Claimant even appears to argue that because other Braun IP videos discuss legal issues on the internet, including issues related to her firm, Braun IP's typical videos can also be classified as internet drama. You're stretching it, Jeanette. Okay, you talking about how copyrights work do not satisfy being internet drama. The argument also lacks any credibility. I forgot that one was in there. They said that argument lacks any credibility, ma'am. You talking about the law is not internet drama, okay? Now, when I get on YouTube and talk about the law, it is usually involving internet drama, celebrity drama. That is what this channel is about. But you explaining how copyrights work so that people will hire your firm cannot be considered internet drama, ma'am. Where did you get that from? And you just pissed off the copyright board by saying that. It lacks any credibility. They're not happy with this girl. Okay. Claimant is a law firm While claimant may also post content online and get paid by TikTok depending on Braun's viewership, there is no evidence that claimant's typical genre in internet drama or that the work did not greatly deviate from Braun's typical posts, which are legal in nature to promote Braun IP's business. The one prior clip claimant created on fair use that was also shown in the episode supports the notion that the claimant's typical videos predictably are aimed at discussion of copyright law generally, not internet drama. They didn't write that, but I'm adding that in there, okay? While it is true that a copyright owner can be harmed by not being allowed to decide who gets to use or not use their work, there is no rational argument here that claimant and respondents were competitors or that use of a small portion of the work to criticize Braun and her position in the Day Braun dispute would have replaced Braun's market for the work to the extent one existed and thus acted as a substitute for the original. So yes, they posted some of your video, but it's not stopping people from viewing your video, okay? They're not even in support of you. They're not saying that your position, they're not re-spewing what your position is, right? They are saying your position sucks. That's what they're saying. Your position sucks. We don't agree with you. They are allowed to do that. Okay, so Braun IP submits 2 sample licenses for prior works of hers, showing there may be some market for licensing some of her works. But as mentioned previously, the work appears to be far different than Braun IP's other videos. And there is no evidence that there is any market for the licensing of short clips from the work or licensing activity for critiques of Braun IP works. Like I said, who is going to pay her $7,500 in order to be able to talk mess about her in their own video? No one's going to do that. They're just going to argue fair use, like what's happening here. In sum, the weight of the fair use factors clearly favors fair use in this case. Accordingly, the board dismisses the claim against respondents with prejudice. So you can't bring this back, Jeanette. Let it go. The board dismisses the claim against Jessica Vasquez and Lily Martin with prejudice, signed by the Copyright Claims Board. So we are through the initial or the actual final decision, right? They say it's fair use. YouTube has said it was fair use. So we should be done, right? We should absolutely be done. YouTube has spoken, which is where the video is mainly posted, and the Copyright Board has spoken. So we should be done. They talked mess about Jeanette Braun on their podcast. If y'all are watching live, Kimmy did go ahead and post a poll of whether anybody would pay $7,500 to use any of Jeanette Braun's videos. Or it says, do you think Jeanette's videos have been licensed for $7,500 before? Why would someone pay $7,500 to talk mess about you on TikTok or YouTube, wherever we are, right? So they didn't pay her $7,500 fee. So she was asking for that back. Court basically, or the board basically said no. Yes, it might have been copyright infringement by playing your video on their video. However, it's fair use. They talk mess about you. We're done. Jeanette Braun says no. Jeanette Braun says, no, we're not done. I want you to reconsider this. I want you to find that they did copyright infringe and that fair use does not apply. Reconsideration requires facts that were not present at the time of the decision, which discovery got cut off in September of last year. Remember that. And it involves new law that has come into play, something that gets rid of the right for people giving commentary to use the fair use defense. But Jeanette Braun does none of that. She does none of that. And the Copyright Board describes it as her rehashing everything that they already went through. So we just covered this decision. It took us, 54 minutes almost to get through this decision. It was very, very detailed, very detailed. The board was very clear in what facts they found important. They were very clear in describing what laws they used to come to their decision. They cited plenty of cases. Like, we skipped at least 2 or 3 pages worth of cited case law finding in favor of Jessica and Lily. They did a good job of going through all of that. And Jeanette Braun says, nope, y'all got it wrong. Y'all got it wrong. So you need to reconsider and basically find that they copyright infringed me. Ma'am, really? So let's go ahead and jump into the Copyright Claims Board's position on this nonsense. And my thing, Jeanette Braun, if you're going to continue to practice copyright law, I think you're going to be on their radar for anything else you file defending your own clients. Because the way they ate you up in the original decision, they said 2 of your arguments shows that you might lack some credibility. They have concerns with your credibility. And then you file a reconsideration and don't even follow the laws for a reconsideration. So let's see what the Copyright Board has to say about her saying, Copyright Board, I know y'all do this every day, all day, but you got it wrong and I'm right. YouTube already told me it was fair use. Y'all already told me it was fair use, but all of y'all are wrong. And Jeanette Braun is right. So let's see what they said. So here's an order on the request for reconsideration. It starts off by saying that claimant Braun IP initiated this copyright infringement claim against respondents Jessica Vasquez and Lily Martin on December 11, 2023. So after she was already told by YouTube that it fell in fair use. The Copyright Claims Board issued the final determination in the proceeding on January 31st, 2025, finding for respondents and dismissing the claim with prejudice. You can't bring this back. So what does she do instead? She says, y'all got it wrong. You need to reconsider this. Okay. As a review of the final determination reveals, this case was not close. You wasn't even close, Jeanette. It weighed heavily in favor of the respondents. They said, as you can review my final determination, you weren't even close, ma'am. You weren't even close to winning, is what they say. They're not happy. They're not happy. Respondents' use of the work at issue was a textbook example of fair use. They're not happy, okay? Many of the arguments made by claimant were utterly meritless. Y'all, we are in the first paragraph. Utterly meritless, some to the point that they undermined claimant's credibility. They said twice, we got concerned with whether you be telling the truth, lady. We have concern with whether you even believe the arguments that you're making. Okay. Moreover, the board did not take a cursory review of the work at issue and its use, but watched both works several times, detailed in the final determination's factual history section, which lays out respondents' clearly transformative use of the works for criticism and commentary. So at this point, the board is like, are you playing with me right now? Are you seeing that I just threw this decision out here willy-nilly? No, I took the time. I watched y'all stupid videos. No offense to any of the videos. I haven't watched either one of them. I watched them videos multiple times, and I gave a very detailed review of what happened in those videos. And you're telling me that it was a cursory review? No, it was not a cursory review. It was a very in-depth review. They are mad. They're not happy with her, okay? Despite the detailed nature of the final determination, like we do this every day, sis. Not me translating the reconsideration determination. We do this every day. We know how to be detailed, ma'am. Okay. So despite the detailed nature of the final determination on March 2nd, 2025, claimant filed a request for reconsideration. A request for reconsideration of the final determination must identify a clear error of law or fact that was material to the outcome or a technical mistake. Okay. Just as importantly, the request shall not merely repeat oral or written arguments made to the board as part of the proceeding, but shall be specific as to the purported error or technical mistake that is the subject of the request. Notwithstanding the rule, the request is simply a 12-page brief rehashing the greatest hits of the party statement claimant filed in the written testimony phase. So you basically resubmitted a document. She said the greatest hits by Jeanette's greatest hits of why she thinks the copyright board don't know how to analyze fair use. Okay. The board could simply deny the request on that basis. The arguments continue to be meritless, and no clear error of law or fact or technical mistake was even presented. You didn't even tell us how we got it wrong. You just said, no, re-listen. Like, did she think that they didn't read her statements? Like, they clearly stated that they read the statements and they pulled facts from both of the statements. And they cited when they pulled facts from each of the statements. So you didn't even say, no, you didn't even follow the reconsideration law. You just rehashed facts that they already read, that they already cited. Okay, let's go on. However, rather than merely denying the request in a cursory order, Jeanette, don't play with these people. Don't play with these people. However, rather than merely denying the request in a cursory order, the board will briefly rehash why the episode so obviously qualifies for fair use for educational purposes. They talk mess about you, ma'am. They talk mess about you. Let it go. You lost. You lost. It's over. We understand you can't bring it back because we denied it with prejudice. But that doesn't give you the right as an attorney to file a motion for reconsideration with no actual things to reconsider. Okay. So let's go back into the factual. We already kind of went over the factual history, but I'm going to read through this again because it throws a little bit of shade throughout it. So we'll go ahead and jump into this one more time. They're going to re-explain to her why she don't know what she's talking about, even though she keeps trying to tell them they don't know what they're talking about. So this is a brief summary. For a detailed factual history, including the many ways in which the allegedly infringing work uses claimant's works to critique it, see the final determination, pages 2 through 7. They gave you 5 pages of facts that they considered, ma'am. Suffice it to say here that the entirety of the claimant work depicts a Braun IP's owner, Jeanette Braun, sitting at her desk recording on a computer or phone camera a generally factual recitation of her position in a dispute with an internet personality named Becca Day. Braun did not like that Day accused Braun of filing false copyright strikes. And I bet you the freaking copyright board is rolling their eyes like this. Like, I mean, it does look like she's filing false copyright strikes because she filed this one against small creators, such as podcasters and influencers on the internet, so that she can get things her clients do not like taken down. Braun's defense to today's accusation in the work is highly semantic, that she does not file false copyright strike, but rather files a request for strike, and the online service provider performs the strike. They're not happy with her. The tea and drama referred to in the work was squarely in the wheelhouse of respondents' podcast. This is normally what they talk about on their podcast. In the course of discussing the Day Braun fight and Braun's position related to that dispute, respondents played a 1-minute clip from the 8.5-minute work and spent approximately an hour commenting on and critiquing it, completely dismantling all of Braun's arguments in the work, as well as expressing their displeasure with Braun's tactics on behalf of her clients. Respondent also discussed at length the concept of fair use. And additionally, and mind you, they're discussing the concept of fair use as creators, non-lawyer creators, right? And they got it right. But Jeanette Braun, as an attorney who practices copyright law, can't seem to get it right. So they're saying they even talked about what fair use was in that video, and you still filed this. Come on, girl. Let me see here. Where were we at? Respondents also discussed at length the concept of fair use and additionally argued that Braun engages in hypocrisy. Why did I say hypocrisy? Hypocrisy by sending takedown notices against instances of fair use and material potentially not protected by copyright, even though she has previously educated the public in other videos as she has published that a fair use analysis should be made before sending a takedown notice. You know how fair use works. Stop playing with us. The copyright board is like, stop playing with us. Okay. On December 3rd, 2023, Braun IP sent a takedown to YouTube regarding the episode, and respondents sent YouTube a counter notice. As previously noted, YouTube's opinion does not factor into the board's decision, but YouTube unilaterally made the decision that regardless of whether Braun IP filed a copyright infringement lawsuit concerning the episode, they would not take the episode down because YouTube independently determined that the episode's use of the work clearly fell within the category for fair use. Again, stop playing with us. Even if you claim you didn't know what fair use was, which you should because you're an attorney and you practice copyright law, okay? You filing copyright strikes left and right, allegedly. Even if you didn't know that, YouTube told you, okay? Stop playing with us. Related to potential damages and market harm, Braun IP stated that it uses a standard license agreement for videos it creates, for which it charges $7,500, and attached 2 sample licensing agreements. It was unclear what types of video the licenses covered and whether those videos were anything like the work, although Braun IP now admits that the licenses were for very different types of videos as the work, as an outlier to Braun's IP's typical material. Again, you weren't even talking about what you normally talk about on your TikTok. Stop playing with us. Nobody's paying $7,500 for your video, sis. Can they write that or no? They go back into fair use. Rather than trying to identify a specific clear area of law, they mad, okay? The request is dedicated to re-arguing the fair use principle, including the first, third, and fourth factors. Again, it would be easy for the board to deny the request on that basis alone, since every point made in by the claimant was already made by her prior party statements. However, it will briefly explain the fair use factors again, since you don't get it. Since you don't get it, let me explain it to you again. Since you confused. Okay. So, however, it will briefly explain the fair use factors again, with hope that Braun IP might change its tactics in the future. So now the copyright board thinks this is my analysis on this. I think the copyright board thinks you file false copyright strikes at this point. I think they are on the sides of the creators. Because hopefully, Braun IP, Jeanette, hopefully y'all change y'all tactics in the future. Let me explain this to you again. Let me run this by you again, since you don't seem to get it. I'm not going to go over the factors again because we literally just went over them. So let's get into the first factor, ma'am, since you don't get it. As to the first factor, claimant understands the esteem that critique. As to the first factor, claimant understands the esteem that critique and commentary explicitly called out in Section 107 of the Copyright Act holds in a fair use analysis. Braun IP argues that the commercial nature of the podcast outweighs the transformative use of the work, but the fact that the podcast was commercial carries little weight when the purpose of the use was to critique the claimant's work. As the Supreme Court has said, the commercial or nonprofit educational purpose of a work is only one element of the first factor inquiry into its purpose and character. And if commerciality carried presumptive force against the finding of fairness, the presumption would swallow nearly all of the illustrative uses listed in the preamble of the Copyright 107 law, including news reporting, comment, criticism, teaching, scholarship, and research, since these activities are generally conducted from a for-profit in this country. So they did both commentary and criticism. And basically, if we followed the rule that Jeanette is trying to get the court to follow, no one would be able to make any commentary while also showing, okay, hey, this is what I'm actually commenting on. That's stupid. Let's not play. Claimant quotes the syllabus as opposed to the actual decision of Andy Warhol Foundation for Visual Arts versus Goldsmith for the proposition that when a secondary use is transformative to some extent, the first factor can still weigh against fair use when the transformative elements are outweighed by other factors, such as the such as the use's commercial nature. However, the Warhol opinion, so you are only partially citing cases, that's a problem. Come on, you're an attorney, girl. Stop playing. Stop playing. However, the Warhol opinion noted that criticism and comment, the purposes of respondents' use of the video clip, are the sorts of copying that courts and Congress most commonly have found to be fair uses, and so may guide the first factor inquiry. Where do we want to go? The court also noted that commentary or criticism that targets an original work may have compelling reasons to conjure up the original by borrowing from it. Respondents' use of claimant's film clip was precisely for the purpose of commentary and criticism, targeting claimant's work and therefore highly transformative. Okay, so they're not playing with her. In short, respondents' use was not merely transformative to some extent. It is precisely the type of highly transformative use that is fair, even when done for profit. So stop playing with them, okay? This is transformative. Just because they talked about you and they made some money, don't mean you win. You wouldn't have made the same money that they made, Jeanette. You were talking about how Rebecca Day was wrong in saying you filed false copyright strikes. Now, the copyright board, who you will probably have to continue to practice in if you continue to practice intellectual property, now they think you filed false copyright strikes. This was a stupid move. Why would you do this? Why would you do this? Y'all, don't forget we are live, and make sure you are letting me know your thoughts on this. We're going to get into the chats in just a moment. We're almost done with the actual document. And then we're also going to get to the poll that Kimmy posted as well. Let's see where we are with likes. I keep forgetting about that. We're at 23 likes. If we get to 30 likes for the live stream, then we will hit our like goal. We're going to make 30 likes our like goal. So if you haven't hit the like button, please do, because Bree is already spicy, okay? We're already spicy and we're not done yet. We're not done. Let me know your thoughts as we go on. So here we go. Let's continue on with the court's argument, or the board's argument. Braun also raises a strange argument while citing some of the cases finding fair use already cited by the board, that the episode recreated the work's creative expression. As already stated by the board, respondents' use of the 1-minute clip to accurately report, not accurately, okay, they are on the sides of the creators, okay? The 1-minute clip to accurately report on the story they were discussing and to allow their viewers to understand the context of the story and their critiques of Braun and of specific content in the clip. The recreation argument is just a different way of stating Braun IP's meritless argument in the prior written testimony that the clip was used for its original purpose, which was to provide Jeanette Braun's side of an online dispute between her and another online content creator. Meritless. They do not believe you, sis. As stated in the final determination, per my last email, stop playing with us, okay? This is a professional cuss out, if y'all didn't get that vibe. It's a professional cuss out, okay? As stated in the final determination, respondents' use for the opposite purpose of any possible creative expression in the work to go through a detailed critique, a 1-hour critique of your nonsense, ma'am. A detailed critique of Braun's content and give reasons why Braun's side of the story did not hold water. There is no doubt that this use falls into the category of criticism and commentary. Why are you acting like this, Jeanette? Can the board write that in there? Girl, why are you acting like this? Why are you acting like this? Braun IP does not seem to have learned. Girl, you're gonna have to change your practice area. You're gonna have to change your practice area. I gotta look who works for the copyright board. They gotta be lawyers, and they potentially gotta be some judges. She gonna have to find a different practice area. I just don't see how she can continue to practice in front of this board. Let's go on. Braun IP does not eat. I can't even read because I'm okay. Braun IP does not seem to have learned a basic lesson from the cases cited by the board. I already done told you. Why can you not learn this lesson? When one video is used to present a point of view and the second video uses the first to criticize that position, the use is fundamentally at odds with the original purpose of the first work, therefore inherently transformative. Stop playing with us. And then they go ahead and cite all the cases that they cited that we skipped over, y'all. All the cases, go back, read it again. It's like when you're trying to do your homework and your parents are getting frustrated at you. Read it again, Jeanette. Stop pissing these people off. She's going to have to find a new practice area. I just don't see how she can ever go back. As Braun IP does not challenge the board's finding on the second factor, they go ahead and skip over it, okay? So let's go on to the third factor. That was all just the first. They were still cussing her out on the first factor. Let's see. On this third factor, the request is certainly no more than a rehashing of claimant's prior argument rejected by the board that the heart of the work was taken. Braun IP does not dispute the board's finding that a small amount of the work was taken. Respondent took only 1 minute out of an 8.5 minute video, which amounts to approximately 11 to 12%. They literally are copy and pasting what they already told you, okay? However, Braun IP suggests that unless respondents could affirmatively prove that the portion taken was not the heart of the work, so now she's putting the burden onto them, okay? If it was not the heart, they can't prove that it's not the heart. Let me just go start over. However, Braun IP suggests that unless respondents could affirmatively prove that the portion taken was not the heart of the work, the board should take claimant's argument as fact, even if there's no evidence to support it. I don't know who needs to tell you this, Jeanette, but they don't believe you. You want the board to take your argument as fact? They already said you were not credible twice in the first determination. I don't think they want to take your word for nothing. Nothing at all, ma'am. Sorry. Let's go on. We should just take her word for it. I have never seen that. A lawyer saying, y'all should just take what I'm saying as fact. That is absurd. Absurd. Ridiculous, okay? No evidence to support why what she's saying is true. But y'all, is that anything new with Jeanette Braun? Do we need evidence? Do we need evidence? In doing so, Braun IP cites cases not dealing with criticism and where a plaintiff actually proved what was taken was the heart of the work. This is preposterous. They mad. They're very upset. This is preposterous, as is claimant seemingly suggesting that this factor must always go against the finding of fair use by arguing that the mere fact that respondents chose this portion of the work to critique it is a prima facie evidence that the clips were the most important moments of the work. Again, claimant only serves to undermine its credibility by making such arguments. Oh gosh, they don't believe you, sis. They don't believe you. They don't believe you. Have you ever thought about doing like tax law or like bankruptcy? Maybe, people need help in that area of law. Because I don't think copyrights are going to work out as a practice area anymore for you. Yeah, they're not happy. I wonder if they got a list of attorneys that be arguing nonsense. I wonder. Okay. As discussed in the final determination, per our last email, Jeanette, respondents used the works to provide context so that they could properly critique it, using no more than what was reasonable and limiting their use of the work to the specific parts they were criticizing. Finally, let's get to the fourth factor. They're not playing with her, okay? Finally, the request fares no better as to factor 4. You still playing with us, ma'am? As an initial point, the request assumes that the board's finding that respondents' use was transformative and used for criticism and commentary was incorrect. It was not. I know they wish they could cuss her out. Like, the way this is written, they wish they could cuss her out personally. That's my opinion. Okay, y'all. She's assuming our analysis is wrong. It was not. And claimant has certainly not shown a clear error of law. The request seems to, in order to re-argue that claimant and respondents were competitors and respondents usurped, you never say that word, usurped reclaimant's market for the work, admit that the work was an outlier for Braun IP's typical videos about copyright law in general. Regardless, as stated in the final determination and as not challenged by Braun IP in the request, Braun IP presented no meaningful evidence that respondents' use of the work affected the market or value of the work. And with this admission, the licenses Braun IP presented with its written testimony go from practically meaningless to absolutely meaningless. They are so mad. So they are saying, we were confused why you provided us with the licensing agreement previously. But we can see like maybe you did license some videos out. But instead of supporting that argument by saying, oh yeah, this is the same agreement, I just changed like the title when I'm giving these agreements to people to license these type of videos. Instead of doing that, you admit that you don't normally make videos on legal drama, okay? You admitted that this was an outlier video, a video different than the content that you normally do. And while we thought that the contracts could have been just something you kind of use interchangeably and you just change whatever the title of the video is, you admit that it's not. So at first we were like, I don't know if these mean anything. Now we're saying they absolutely do not mean anything. Jeanette, you played yourself. You played yourself in this. Bankruptcy, tax attorney, maybe? Anybody got an opening for a job? I wouldn't be able to file anything else in the copyright board if they ate me up like this. Okay. Multiple of her motions are being dismissed with prejudice. That is not a good track record. In the federal courts, her claims got dismissed with prejudice. In the copyright board, she's getting dismissed with prejudice. And they're telling you what you're saying absolutely means nothing to them. You lack credibility. Your arguments are meritless. As an attorney, we hope you change your tactics in the future. Y'all, let me finish this so we can get into the comments. The board is not happy. Okay. They're not happy. Okay. Respondents took a small portion of the work to criticize its content, full stop. As stated in the final determination per our last email, there is no rational argument here that claimant and respondents were competitor or that use of a small portion of the work to criticize Braun and her position in the Day Braun dispute would have replaced any possible market Braun had for the work and thus acted as a substitute for the original. Quotations. We already told you this, sis. In sum, Braun IP, which promotes, I'm telling you, she can't find nothing else here. Braun IP, which promotes itself as a law firm knowledgeable about and experienced in intellectual property law, has not presented any argument that would amount to an error of law or fact, never mind a clear one or one material to the final determination. You just rehashed the facts. The request for reconsideration is denied. Stop playing with us. Can they please write that in the next one if she files anything else? Stop playing with us, ma'am. Stop playing with us. Because what do you mean we got it wrong? Like I said, this court has said we have concerns with your credibility. Your arguments are meritless. You promote yourself as being knowledgeable in intellectual property. Copyright law falls under intellectual property, and you're making these bogus arguments. We hope that you change your tactics in the future. Are the tactics that they're talking about are the alleged false copyright strikes? Because you didn't like what was said about it. Like, let's be honest. The reason why we're filing this Because we know, even people here on YouTube that are not lawyers and you don't practice copyright law, we know this fell within fair use. Any plain reading of the statute, any lay person would understand they were talking mess about you. And you said the purpose of the video was to bolster what you said. My question would be, how does that hurt you if they're supporting your position? Wouldn't you want your position to reach more people? It makes no sense. So you played in YouTube's face when you filed the original copyright strike. They told you it was fair use. And you said, I'm an attorney, so I'm going to go ahead and file it directly with the copyright board. And you came and you played in these people's face. And not only did you come and you played in these people's face for the first determination, you turned around and played in these people's face the second time and told them that they got it wrong. So YouTube and the Copyright Claims Board got it wrong and you got it right, but you got videos on your channel explaining how fair use works and that you need to consider that before you file stuff like this? Stop playing with these people. Like I said, anybody got a tax lawyer job available, because I would not show my face again. I would not put my name on another document being filed with the Copyright Claims Board. I just wouldn't do it. I wouldn't do it. Now I got to go see if she was the one representing herself or if she was represented by a separate attorney, because there's no way. There's no way you went in there and played in them people's face twice. There's no way. Let me get on the goddamn website to see if she was represented by another attorney in this case, because I just, as an attorney, how could you ever show your face again? Let me see. Go to electronic filing. Agree to the terms. Search cases. When I searched Jessica, it popped up. So let's search Jessica Vasquez. Okay, let's see. Am I spelling it wrong? Okay, it popped up this time. Does it tell us if she has a lawyer? It shows, let's share the screen. Okay, so we're on here. It shows the parties right here. Braun IP is the claimant, and then we have Jessica Vasquez and then Lily Martin as respondent. Let me go all the way to the front to see if she has a attorney. Let's look at the claim. So the authorized representative is Jeanette Braun. Okay. Let's see. I don't see that she has anyone else representing her. So I'm thinking she's representing her law firm in filing this. That is what I'm seeing right here. I don't see anything saying that she had a substitution of attorney or anything of that nature, but I'm also not going to stay on here for a long time. Okay, here was the second filing. Or notice to file the second filing. Okay, do we have claim response? Let's see who they sent it to. Oh, everything is done online. I'm like thinking that these are going to be court documents that are going to be sent. Okay, no. So I'm not seeing anything. Is there a proof of service? Yeah. So I don't think we're going to be able to see. I think she represents herself because on the claim form, as y'all can see, it says the organization, the claimant is Braun IP, and then the name of the authorized representative is Jeanette Braun. And then it also cites her as a certified role of in-house attorney. So I'm assuming she is being the attorney for herself in this lawsuit. So there's that. So with that, I don't think she's being represented by someone else. Oh, let me just actually look at the filing that she did. Who signed the filing? Because I do have that. This is what happens when you do stuff on live. Okay, where is it? Her request for reconsideration. Braun IP. And it is... No, it's submitted by John Marianne. Okay, so she had an attorney representing her. Is this the same guy that filed the Is this the same guy that filed the original one? Oh, Kimmy was trying to get me. Oh, click the party list. Okay. Okay, so yeah, she does have an attorney. Thank you, Kimmy. Sorry, I just looked at the party list and was like, okay, she does have an attorney. Did all of that to learn that she does have an attorney, okay? She does have an attorney, which is John Marianne, number 4 from Lockyer Law. That's her attorney. And they were self-represented? No. And Kimmy is saying that it's the same attorney that represented them or same firm that represented Jeanette Braun in the defamation case, but a different attorney. Thank you, Kimmy. So, Jeanette Braun, who advertises herself as an intellectual property attorney that covers copyrights because apparently she is being accused of filing copyright strikes and false ones at that. That's what she's being accused of. So she seems like she should be well-versed in copyright law. She's intellectual property. She makes videos on how copyright law works. Right. She hires her own attorney, Mr. John Marianne, from Lockyer Law, who I'm assuming also practices intellectual property, but I can look him up. He practices. She was an attorney. And they lost to non-represented parties about fair use? You have got to be kidding me. Like, you have literally got to be kidding me. I want to see now. I gotta see this guy's law firm. Lockyer. Sorry, y'all. We are way off track. Lockyer Law LLC. Who is this guy? There's Benjamin Lockyer. He's not listed on the website, so I don't. Does he not work there, or like what's going on? What's going on? He's not listed on the website. We are on a side quest, crazy guy. We are on a side quest. What was the name of the other guy? And then I'll get into the chat and what y'all think about everything. But no way. No way. What am I doing, Bree? Where is Jeanette defamation? I don't know. I don't got time. Who was the attorney? Kimmy, do you know who was the attorney in the defamation case? Because I don't know if I have the Jeanette Warren. I should have it actually in our shared one, huh? Lauren the Mortician. Oh, Kimmy probably got to it faster than me. It was Benjamin Lockyer, who is the one that how did you find his page? He was not listed when I clicked on attorneys. Well, apparently he still works there. So let's look at this guy. We got our good friend, John Marianne. He is an attorney at law. He has an extensive background in intellectual property, and you wrote this and managed the portfolios of both startups and Fortune 100 businesses alike. With a focus on patent procurement, John works directly with countless engineers, designers, programmers, and startups to get IP protection. That stay with the patents, because with the copyright, sir, stay with doing patents, because this didn't work out for you. This did not work out for you in the copyright. So let's look at intellectual property management. John focuses his intellectual property service on managing trademark and copyright portfolios for clients. In addition to his patent services, John also works on the alternative solutions, such as developing trade secret protection plans. John's holistic approach allows him to help clients develop and protect their ideas at various phases of growth. He does transactions and litigations. In addition to his transactional services, John is also a skilled litigator. I mean, that might be questionable. Whether you are looking to enter into a contract or wanting to settle a dispute, John is able to review, negotiate, and enforce agreements of all variety. I mean, that's what it says. That's what it says. As well as a well-rounded business attorney, John's extensive experience makes him a skilled advocate that protects his clients' interests in both short and the long-term basis. So did she tell you to file that, or were you like, yeah, we should file this? Because there's no way. There's just no way that you filed this. I can't, y'all. He says he does copyright. He said he does it. Who am I to say that he doesn't do it? Who am I to judge his skills? Because I would have told my client, absolutely not. Absolutely not. We're not doing that. We are not doing that. Let's have Bossy B. Because what do you mean you practice intellectual property law? Now I want to look and see how long he's been an attorney, because it does not say when he became an attorney. But I mean, Mr. Lockyer, he looks young though too. I could just be judging on looks, but honestly, they both look pretty young. Hey, where did that one go? Oh gosh, I lost the one that Kimmy just sent me. Baby Ben. Thank you, Kimmy. Not Baby Ben. And John. He looks young too. So I'm wondering if they're both new lawyers. Can we? I know I said I was going to go into something else. I think they are in Illinois too. Illinois. And you had an attorney and you still lost to these people? I'm sorry, y'all. I said I was going to stop deviating, but I can't now. I'm too deep in. At this point. His name was Benjamin Lockyer? Oh, no one popped up. Am I on the right thing? Illinois State Bar. I know I said I was going to be off of my thing. Look, they are in Illinois, right? Because I just automatically went to Illinois and I might be wrong. Okay. And then his name is Benjamin Lockyer. I might have spelled it wrong. So here we go. Let's just copy it and go straight to Lawyer Finder. I gotta sign in. Why can't I just search a lawyer for the public? Find a lawyer. I think it's gonna make me create an account. Oh no, here it is. Oh, so I was on the right page, but when I'm typing in his name, it doesn't come up. Like, it literally doesn't show anything. Like, this is what it's giving me. I am typing in his name, Benjamin Lockyer, and then let's take him off. Oh, what the heck? How did that happen? Benjamin Lockyer. And it just disappears. No one's there. And then the other guy is what? John Marion, right? John. Okay, he popped up. It says he works for a different law firm, though. He's in the Young Lawyers Division. Okay, let me actually share it with y'all. Oh, I am sharing it with y'all. I didn't even know. Education. Loyola University Law School. License. Let's see his license. Where's his license? Oh, 2019. So he's been a lawyer for at least 5 years. But it says he works for a different law firm. So I'm wondering if this is new or old of him working for this at Sullivan and Carter LLP. So that's interesting. But Benjamin Lockyer does not show up. Lockyer. He doesn't show up. I tried Ben and I'm trying Benjamin Lockyer. He doesn't show up. So I don't know. I don't know if this Ben guy is what's going on with him, but he doesn't even show up. Does Jeanette Braun show up? Not you being messy. But Jeanette Braun also doesn't show up. So maybe I'm doing this wrong. But John showed up. Jeanette's not showing up. I'm not kidding, y'all. I just typed in Jeanette Braun's name. She is not showing up. Unless I have to capitalize it. Braun. No, she's not showing up. Let's see if I do like here. Then I'll give up, y'all. This is my ADHD going crazy right now because I cannot find these people. But John showed up. John Marion. He shows up. So the website works. I don't know if adding an initial, because I didn't add the 4 for him and he still popped up. Can we put the initial? Am I spelling it right? Jeanette. What is it? M. Braun. I can even type in the she's not showing up. So I don't know what's going on with that. That's a bit strange. Anyways, let me actually jump into the comment section. But before we do that, I'm gonna go ahead and check the vote. Kimmy posted a poll that I asked her to post. Thank you for that. Saying, do you think Jeanette, or Janet, I'm like, why is this spelled? Janet's videos have been licensed for $7,500. 20 people voted and everybody said no. So no one believes the $7,500 charge she's given to people for renting out her videos to allegedly talk mess about her. Thank you for everyone that voted on that. Let's see where we are with the likes. We are at 29 likes, y'all. I said if we hit 30 likes, then we hit our like goal for the stream. So if you haven't hit the like button, please do. It does help us out. And it will help us set our like goal. So let's see if we can get our like goal animation played today by hitting 30 likes. Shout out to the BriHive on that. Let's see what the BriHive has to say, because this is ridiculous. I done went on a whole wild goose chase to see the licensing of these people. And when I tell you, Jeanette Braun didn't show up and her attorney Benjamin Lockyer didn't show up, but John Marion, who is an attorney that apparently works for him, but his bar website says he actually works for someone else, that is a little fishy to me. And I would like to know what's going on. I know other people have looked her up before, so I'm wondering why she's not popping up on my end. I could just be researching it wrong. I don't know, but that is very, very interesting to me. Maybe there's some other way to search her. But anyways, let's go ahead and jump into the comments and see what everyone has to say. We got Phoenix Waller saying, yay, time for another Janet roast. Yes, I mean, there was nothing else we can do. The copyright board ate her up. And like I said, I would never show my face again in the copyright board if I got answers like that from the court. And then I wanted them to reconsider it, and then they cussed me out some more, like hoping that I changed my tactics. So now they're on the side of the creators. And these creators were unrepresented. And she still lost. And she had an attorney. Come on now. Okay. James Stoddard says, hi, hey, Bri et al. Hello. Saying Ian's been following this from day one. It is madness. I have followed it on and off. I know Ian has been on it. I just don't want to get on Jeanette's radar. I don't want to get on the radar. It's ridiculous. Kimmy Locker says the Copyright Claims Board essentially told Janet her arguments were bad and she should feel bad. They said, I hope you change your tactics in the future. I hope she changes her practice area. That's where I am. I think copyright, we got to give it up at this point. And I'm like tempted to go and look up like if she's still on TikTok, because I wouldn't be. I wouldn't be. I would change. Like, if you hired her and then you searched her name and this kind of stuff popped up about her, would you want to work for her? I mean, would you want her to work for you? I wouldn't. Getting cussed out by the copyright board and the federal court is crazy. That's crazy work. Okay. Bruce Matskin says, I think you'd be excellent for covering the what the hell's bad neighbors case. It needs a serious lawyer on YouTube covering it. I think I got an email about that. I just have been busy and haven't looked into it. Thank you very much for that. I have an email. I'm pretty sure I have an email about that one, so I will need to look into it. Thank you. Bruce says it's full of bad lawyers angles. Okay, well, we like that. We like that over here. Phoenix Wallace says it's Janet. Of course, she'll proceed and probably argue against the dismissal with prejudice. Girl, if she come back, if she comes back after that read, two reads in 2 months. You got to get tired at some point. You got to get tired at some point. Phoenix Wallace says, did she register the copyright before or after the girlies used it? Because it costs to register. Is she just willy-nilly paying for that fee for everything, packaging them up like over the top? Normally, people file it when they're getting ready to sue, because I mean, I make YouTube videos multiple times a week. I'm not going down to the copyright office and filing, but I think it's like $65 every time I make a YouTube video. I'll use my common law rights until we need to sue somebody, but nobody uses my stuff like that. So that's not a big deal for me, but I'm going to assume the registration is on here. The registration is on there. Let me see. I'm not going to assume. I'm just going to go ahead and find the registration because it is on the docket. I believe it was Exhibit D, they said. Yes, here we go. You ask, so you shall receive, to know when she filed it. So she filed this. Uh-oh, what's going on with my screen? I want to be in this corner. Okay, so she filed this on, it says the effective date was December 5th, 2023. The first publication was November 29th of 2023. So it sounds like the video came out on December 2nd of 2023. So it looks like she filed it pretty much immediately. They got approved really fast. It got approved really fast because she filed it on the 5th, and it was effective on the 6th, I guess. It doesn't tell us when she actually made the file, but I'm assuming she did it pretty immediately because it's registered just 3 days after the video went live. Or look, the video went live on November 29th and she had it registered by December 5th. So I would assume that she filed it pretty much immediately, but this is all within like a week span. So, yes, most likely after the video went live, but I'm not sure. But I don't think she's going around filing copyright registrations for every video she puts out, because that's expensive. Okay. Xylee Gets Sassy says, I watched Runkle of the Bailey cover this. If I were her lawyer, I would have fired her as a client. Absolutely. You can fire your clients. That's why the thumbnail is the worst client, because she needed to be fired. She was horrible. Phoenix Waller says, Jeanette to others, consider fair use rules. Jeanette, when it's about her, rules for thee, but not for me. Seriously, that is exactly what we just got. No, I don't see that. To the point where the copyright office says she clearly has not learned from what we said last time. She is an intellectual property lawyer. Like, this is embarrassing, y'all. This is so embarrassing it's embarrassing for her. It's embarrassing for me. Like, why are you doing this? Let it go. Okay. Bud Light says, this case is mind-blowing to what a YouTuber has done to private citizens. Yeah. She put herself on the forefront. And honestly, I would not hire her for my attorney. I wouldn't. But I wonder if she's going to continue her firm. Like I said, I think she should change practice areas. Penny Gray says, would Janet have to self-report to the board that a finding of not credible was levied against her? I don't know if it was a finding of not credible. It says that it goes against her credibility. I don't know if we can call it a finding. I don't know. Do you have to? I don't think you have to report yourself, but I know the rules are different in each state. In California, if a lawyer is doing something bad, they're not being ethical, we are required to report it to the bar. The judges are required to report it to the bar. I don't know how it works in Illinois. And like I said, I can't even find her on their website. So either I'm looking at it wrong or they're not registered on that website. I don't know, but I can't find her. Okay. Kimmy Locker says, the Penny Grace, I doubt it, but in the thing about it also, what I didn't say in this, she probably don't think she did nothing wrong. So why would she report it if she don't think she did nothing wrong? She thinks that the copyright board got it wrong. But Kimmy says, the Penny Grace, I doubt it, but future legal opponents can and almost certainly will use it against her whenever possible. Yep. She is creating a very bad track record for herself. Destined to Be says, thanks everyone for hitting the like button. Bossy B, appreciate it. Yes, of course. Thank you for thanking them while I was deep into the documents. Kimmy Locker says, and don't forget to confirm you're still subscribed. BriHive YouTube likes to helpfully unsubscribe people for what reasons we don't know, but hopefully you are actually subscribed to the channel. Randy Stickler says, not even close, Janet. Janet got cussed out. Professionally, in my opinion. Okay. Justin the B says, basically the board said per my last email. Yep. Exactly. Per our last email. Get out my face. Penny Grace says the greatest hits. Yeah. She recited the facts. And I haven't actually read her request. So I do want to go back and look at it. I just knew that would make the live stream entirely too long. Okay. Penny Grace says, for educational purposes, I would die if I got that comment at my job. Like, really? Like, hopefully you change your tactics in the future. Like, is what the creators have been saying, is it true? Because, like, what do you mean the board is saying you need to change your tactics? This is fair use, ma'am. We already told you that. What is embarrassing? I would have to change my whole practice area because I could never file something. And like I said, she did have a lawyer representing her, so maybe she don't feel as embarrassed. But the fact that you're promoting yourself as a copyright attorney or an intellectual property attorney and you make copyright videos, and in the video that you're saying is copyright infringement, you explain how fair use works. In that video, you didn't strike them for that video. You only struck them for the video that they talked about you for an hour. Talked mess about you for an hour. So yeah, I would quit. I wouldn't be an attorney. I wouldn't be an intellectual property attorney anymore. No, I'll let it go. Kimmy Locker says, I love how CCB, Copyright Claims Board, said it could merely deny the request, but will rehash it for educational purposes. Like, even the way they said it, we've got time today was shady. Yes. Yes, I even missed that. So thank you for catching that. Girls, stop playing with us. Because when you try to appeal this, it's going to be a problem. It's going to be a problem. So imagine, because I think you could probably appeal it. I don't know. I've never filed a copyright claims board thing, so I don't know if you can appeal it or not. But yeah, you're right. They did say, we got time. You failed. You didn't even state a claim. Failure to state a claim. Is that not what she got dismissed for in the federal case with the defamation and stuff? Failure to state a claim. Oh, girl, this is embarrassing for you. This is really embarrassing for you. Doopliness, love the name, says you can boss me around anytime, Brie. Thank you. I know Spicy Brie came out today. I'm sorry, y'all. I was not expecting such things. Doopliness says, I like the lawyers that sue porno pirates. They get scared their name is going to be attached to all their pornos. I saw those cases and I thought about covering it. I don't know if I would get kicked off of YouTube for it, though. I saw those cases. Kimmy Lockett says to Doopliness, Braun should have been scared about her name being attached to this claim and the defamation suit, in my opinion. Absolutely agree. Absolutely agree. Doopliness says, inherently, ergo, accordingly. Ergo, accordingly? Concordingly? I don't know if I know what that means. I don't know everything, y'all. Penny Gray says, probably not often preposterous is used in a legal filing. In a board decision. Your position is preposterous, ma'am. You are the problem. You are the problem. Could the copyright board just say, ma'am, you are the problem? They might be right about you. I don't think they should go for it. So, I believe Kimmy made this comment when we covered the decision on the defamation case. Somebody made the comment, I believe it was Kimmy, but I can't remember all the way, of not thinking that Jeanette Braun would go forward based on this decision. When that comment was first made, I was like, oh, I'm thinking that the copyright claims that she filed was regarding the actual video in the defamation case, but it's actually regarding a different video, right? Or am I wrong? I could be wrong. I'll wait till the comments come up and see if I'm wrong on that. But imagine her going forward against Lily, because remember, it's against her statement regarding a tweet that she made. And I don't think it's the same video, but y'all can correct me if I'm wrong, because I think that lawsuit came out prior. Or was that lawsuit filed last year? I don't know. Anyways, imagine, what do you call it? Lily, the statement that she made is that she believes that Jeanette Braun commits perjury on legal documents. And imagine Jeanette Braun being on the stand and saying, no, I don't commit perjury on the stand. And then Lily Martin's attorney calling the copyright board to the stand and having them read that decision. Both of them, 3 points of them saying that she was not credible. It goes against her credibility. She promotes herself as this copyright lawyer, but she doesn't even follow the rules. She got to drop that case. She cannot go forward against Lily Martin. She absolutely cannot. Or they might just take judicial notice of that document. But I guarantee you, whoever is on the copyright board will be happy to testify against Jeanette Braun and her lack of credibility in legal filings. Disingenuous, meritless, preposterous. These are not words you commonly see in legal decisions. It's absurd. It might as well, like I said, girl, stop playing with us. Might as well. But yeah, preposterous and everything else. I would love to see Jeanette Braun try to get on the stand with these type of words used against her in a legal document that the court can take judicial notice of. Destin DeVee says, wow, she brought all this smoke on herself. She did. She could have just scurried along and no one would have paid attention to her. She played herself. Crazy Cat Queen, thank you so much for the $5 super chat. Definitely appreciate it. Saying, thank you for keeping me company as I study for my Japanese exam tomorrow. Well, good luck. Your laughter gives me energy and makes me smile. I don't understand how you could study with me yelling. I have no idea how you were able to concentrate with me shaking the table. But thank you. I very much so appreciate it. And good luck on your Japanese exam. Hopefully your teacher doesn't put fake things on there and try to trick you up like how we're seeing allegedly what Jeanette Braun is doing, right? Because we know people like to sue. Okay, but thank you so much for the super chat. Kimmy Locker says to Destined to Be, unforced error for sure. The Copyright Claims Board came at Janet like her request for reconsideration made them miss something important. Exactly. They were like, absolutely not. You stop playing with us. Stop playing with us. Destined to Be said denied. Absolutely denied. And don't show your face around here again. If they could write that in there, they probably would have wrote that in there. Okay. Crazy Cat Queen says, I was another attorney, someone that she seems to have connection, or it was another attorney, someone that she seems to have connections with. Yes. So we did go off on my loose rabbit hole of the attorneys and not properly clicking the parties list. Because why would I not do that? But I didn't. Anyways, she was represented by a young attorney. He is a young attorney. So maybe he hasn't developed the skills to say no. I don't know, because I wouldn't file that. And I'm a young attorney. I was licensed in 2019 as well. I would not have filed any of this. Any of it at all. Not the defamation case and not the board case. You have created notoriety. People know who you are, Jeanette Braun. Like, girl, you created notoriety for yourself. Not a good notoriety, that's for sure. It's not good, but you should just stay quiet. That would be my opinion. Destined to Be says, I don't trust anyone who represents her either. Absolutely not. No. They should not have put this on their career, especially being a young attorney. Crazy Cat Queen says, I bet money that she wrote everything and just made the Locky Ear folks sign it. LOL. That I would not be surprised with. Because she knew if her name was signed to any of these documents, YouTube would have ate it up. YouTube would have ate it up. Because ain't no way his boss approved those documents. He's listed under a whole different law firm online, but I don't know. I wouldn't be surprised. Kimmy Locker says, a Crazy Cat Queen, that's my suspicion. Why are we all on the same wavelength on this? Autumn, the ADHRD, love the name, says, IDK wouldn't trust her with taxes for sure. I threw that out there, but we for sure getting audited. Never mind. You're right. Let's not go into taxes. Destined to Be said, that's true. That is true. I spoke too soon. Maybe a nice, job taking care of cats. Maybe. I don't know. Julian says, I'm really only an expert in bird law, to be honest. Well, maybe she can join you in bird law. I don't know. Crazy Cat Queen says, Jeanette should not do tax law. Too many people would be hurt losing money when she screws it up. Yeah, you're right. We would all be audited. That was the wrong area for me to suggest. I don't know which one she can go into, though. I was just trying to suggest alternative practice areas, because copyright, you can't show your face in the copyright board again. You can't. Destined to Be says she doesn't need to practice any type of law. It might be time to retire. It might be time to retire. Phoenix Lawler says to Destined to Be, agreed. Do we really expect them to pull her license yet? No. They probably won't. They won't. Now, if there was no bar complaints against her before, there might be some now. There really might be some now. Destined to Be says to Phoenix Waller, with the foolishness I've seen while watching these trials, I don't expect any repercussions. Exactly. It's really hard for attorneys to get in trouble. It really shouldn't be hard for us to get in trouble, but it is really, really hard for us to get in trouble. Don't know why it's like that, but it's hard. spend all that money on law school, I guess, and taking tests. Kimmy Lockett says the Phoenix Swaller, not yet, but if she keeps pushing in the defamation case and there's a legal finding that she committed perjury, then she could be in for a world of hurt. She got to leave these people alone. I'm thinking the other dude is a young attorney as well. That's probably why we're not even finding him on the listing. Don't ruin these people's career. Because no, in my opinion, no skilled attorney in these practice areas would have taken that case. I wouldn't have taken that case, and I don't even file anything in front of the copyright board. She out of her mind, in my opinion. You know, you got to say that on these streams because she'll get you. Could you imagine boss attorney Bree being sued by Jeanette Braun for saying she can't go into tax law? Y'all gonna get me in trouble. No, I'm gonna get myself in trouble. Bree even spicy the whole stream. Okay. 2 hours and 4 minutes of audacity. Crazy Cat Queen says John needs the money from Jeanette for harming his career. Man, you don't want one of those type of lawsuits to come against her. Stop playing with them, okay? I wish I knew who was the people on the copyright board. Can I know your names? Because y'all read her. Y'all are not playing any games, okay? Kimmy Locker says the crazy cat queen. Nah, John needs to not sign his name on nonsense. Absolutely. I agree. Destin the B says, I show 30 likes. Thank you for that. Where are we? We are at 33 likes. Shout out to the BriHive. Okay. We have hit our like goal. For those of you that are new here, we have a like goal animation. And if you're sensitive to noise, there's a loud explosion at the beginning of it. So if you need to turn down your volume, this is your time to do so. In 3, 2, 1. All right. Shout out to the BriHive for hitting the like goal. I definitely appreciate y'all. This has been a wild ride of us talking about Jeanette Braun and her nonsense, okay? Crazy Quack. I don't know why I can't. Like, is this supposed to be an alliteration that I cannot say? Crazy Cat Queen says now 31. Thank you. Crazy Crack. I can't say it. Dang, essentially, 2 attorneys lost against 2 non-lawyers. Haha. Yes, that is what happened. That is embarrassing. It's absolutely embarrassing. What's going on? KP says, they said, check yourself before you wreck yourself. And hopefully you change your tune next time you come up in here, okay? Change your tune. Crazy Cat Queen says, but couldn't going against her credibility mean, are you seriously this stupid? I mean, they said that in a professional way. I think that's their opinion. I think their opinion now is that, yeah, she does file false copyright strikes. She knows she's going to lose on fair use. Okay. Kimmy Locker says, I don't know if the video from the Copyright Claims Board claim was specifically addressed in the defamation lawsuit, but it's related because the Do We Know Them podcast for commenting on Jeanette / overall situation. Yes, the one that stuck is the one of her saying that she signs her name or she commits perjury. And it was on a tweet. So I don't know what video that came after, but she can't go forward. She cannot go forward with this defamation. And if she's going to go to lawyers that are going to support her nonsense, she needs to not do that. She needs to go to an experienced attorney. I don't know how long Lockie has been licensed, but Mr. Marion, only 6 years. I know I am the same amount of time licensed. I'm a baby attorney. You're a baby attorney, in my opinion. She needs to go to somebody with 20 years experience in this, okay? And ask them what they think. What do you think? Okay? And when they tell you no, you let it go. Don't go forward any longer. Let it go, let it go, let it go. Because you played in them people's face. And they didn't like it. They did not like it. Kimmy Lockett says, I wonder if Ben Lockyer caught so much flack for representing Lauren and Braun in the defamation suit that he made a junior attorney in his firm put his name on it instead. My thing is, like, he looks like a junior attorney to me. I could be wrong. Lockyer looks young to me as well. I could be wrong, but maybe, I don't know. I couldn't find him on the website, so I don't even know when he was licensed. Autumn, the ADHD RD says, real estate attorney, LOL. I mean, do we want her analyzing homes and the contracts? I don't know what she could do. Maybe she should just take a break, take a gap year. Let's just take a gap year, okay? Let's put the practice of law down for a little bit. Let's do that. Crazy Cat Queen says, Autumn, the ADHD RD says, actually, that might work pretty well. I studied real estate in Texas, and as long as she just did the paperwork, she'd be fine. I mean, she did paperwork to file this, and we see how that's going for her. She filed a copyright strike. That's paperwork. It's not going well. I don't know if I would even trust her with that. First of all, I wouldn't hire her as an attorney at all. Okay. Autumn, the ADHD RD says, it's what my husband's uncle does. Are you saying something about the uncle without saying it? No, I'm just kidding. Kimmy Locker says, the Autumn and Crazy Cat Queen. I can see her representing clients who told those dang kids to get off their lawn. Exactly. Harassment. Okay. Destined to Be says, no seasoned attorney would touch this. She had to find some gullible attorney to do it. I would assume that both of them are young attorneys. I don't know as to Lockie, but at least to Marianne, 5 to 6 years practicing. You're a baby attorney, in my opinion. Like I said, I've been practiced the same amount, or I've been licensed the same amount of time as him, and I would consider myself to be a baby attorney. So yeah. Crazy Cat Queen says, pride goeth with the fall. Shush, I fear she's not done. I fear that she's not done. Phoenix Zola says, let it go. Let me give me a little voice, because you know I can't sing. Let me get a voice. I don't know.
Is my voice change? Oh, I can't hear the voice
change, so I'm gonna let it go. Y'all could probably hear it, but I couldn't hear it. And I don't remember how to make it so that I could hear it. So we're not doing it. I was gonna sing for y'all, but I'm not. Let it go like Frozen. For sure. Let it go like Frozen. Y'all, this was nonsense. I saw Runkle cover this the other week, but I didn't get a chance to watch it. And this was absolute ridiculousness. I don't really know where we go from here. Okay. I think she got to let it go. I don't think she can go forward with a defamation lawsuit, because as soon as these decisions get taken judicial notice of, and the court reads that the copyright board thinks that she lacks credibility and that she needs to change her tune and claiming that things are copyright strikes, meaning that they think you lied. Okay? That's what I got from it. Y'all can let me know if y'all got something else different from it. I'm sorry, y'all. I'm still yelling. Because I'm mad. I'm not mad. I'm like, girl, what? What are we doing here? You can't be serious. Like, this went through your mind and you was like, yep. Like, why? I just don't think she can go forward with the defamation claim, because the copyright board essentially called you a liar. How could you possibly come back from this? I think that the Copyright Claims Board did a wonderful job in explaining their position. They were detailed in the first determination. They were detailed in the second when they didn't have to be. They said, you did this wrong. We don't even need to talk to you. But since you want to play, let's play. I think she got to let go of the defamation. I don't think she should go forward against Lily. That's the only one that stood. Like I said, she can bring something back against Rebecca Day. This whole copyright claims thing name dropped almost everybody that was in the controversy, okay? I think she got to let it go and move on. The federal court then cussed her out, and the Copyright Claims Board then cussed her out twice. I think she's had enough being cussed out for 2025. Maybe we try again in 2026. Alan says, you're not mad, just disappointed. Yeah, I guess. It's just ridiculous. It's just ridiculous. that she had the nerve to do this. I hope the attorneys that filed on her behalf, I think they need to drop her as a client. I would drop her as a client. I would never filed any of this stuff. How do you get a notice from YouTube and saying, no, we don't think it's a copyright because of this reason? And then you file it with the board and they say, no, we don't think it's a copyright violation, or there's a defense to the copyright violation. And then you go say, no, y'all got it wrong. Y'all must didn't hear me. Mind you, all of this stuff is in writing. Okay. So they were able to reread it at their own pace. Okay. They comprehended it. She said, I don't think y'all heard me. She needs to pay me $13,000. It makes no sense. It makes no sense, y'all. But that's all I got for today. Crazy Cat Queen says, I'm on the East Coast and it's almost midnight. I better get to bed. Good night, y'all. Thank you for keeping me company. Thank you for joining, and good luck on your test. Autumn is saying good night. That's all I got for today, y'all. I will see y'all on the next live stream. I am starting my new job on Monday, so I am not sure how streaming is going to work for us next week, but I will definitely keep y'all posted in the community tab. Let y'all know if we're going to be live streaming on Tuesday, Wednesday, and Thursday of next week, or if there are going to be any changes to the schedule moving forward, because like I said, I am starting a new job on Monday. But thank everyone for joining me and listening to me rant and scream and be very upset with Miss Jeanette Braun. And I really hope this is the last that we see her name in lawsuits. I really hope she doesn't get a hold of this video and get mad at me, as I was not very nice. I had comments, I had thoughts, but yeah, hopefully we don't see her in any more lawsuits. Hopefully the defamation lawsuit drops, and hopefully we don't see an appeal on this copyright claim. I will see y'all all on the next live stream. I hope you have a wonderful weekend, and goodbye.